Hello and welcome to Summit County Public Health's Privacy Law Training. The goals of today's training are to help you better understand confidentiality and privacy laws, particularly HIPAA, to better understand how the Health Information Technology for Economic and Clinical Health Act, known as the HITECH Act, impacts HIPAA, and to identify relevant privacy issues in day-to-day practice. So let's start by looking at some sources of privacy law. Did you know that there is nothing in the Bill of Rights that guarantees you a general right to privacy? It's been up to the state and federal government to develop privacy laws which don't necessarily transfer into rights for a health professional or a patient. But the law has come a long way in recent years. The next few slides list just some of the laws governing patient privacy. The oldest confidentiality law is the common law privilege of doctor-patient or counselor-patient confidentiality, which is now codified in the Ohio Revised Code 23-1702. This old law is still recognized as a professional standard of care. Medical professionals and mental health counselors are expected to keep patient information confidential. Professionals can be sued for breaching a professional duty of care. The Ohio law on public records is found in ORC 149-43. It tells us what records should be considered to be public. If and only if they're considered public, we must produce them to a requesting party. ORC 370117 addresses more specific concerns of when a health district should share health information as part of its public health functions. HIPAA, originally passed in 1996, is the landmark federal law which significantly tightened the rules on patients' privacy rights, but it was also intended to make sharing of information for medical and billing purposes more streamlined. HIPAA rules were also adopted as part of Ohio law in 2013. In 2009, HIPAA was amended by federal law under the HITECH Act to contemplate the many privacy issues which can arise in using electronic medical records. In 2013, HIPAA was changed yet again based upon public feedback to the Department of Health and Human Services. The 2013 changes make HIPAA even stricter in terms of the safeguards which must be taken to avoid so-called breaches of HIPAA rules. Violating HIPAA, even once, can result in heavy fines and even criminal charges. When Ohio adopted these federal rules into the Ohio Revised Code in 2013, it created a statutory duty of care under state law, which could open Summit County Public Health up to civil and criminal liability. This can potentially open the door for future lawsuits for breaches of a client's expectations of privacy under HIPAA. For employees who work in the counseling division or who may encounter counseling clients in the course of their work, it's extremely important to know that 42 U.S.C. Part 2 places very strong restrictions on the sharing of information from alcohol and drug counseling. Neither HIPAA nor 42 U.S.C. Part 2 requires Summit County Public Health to release alcohol and drug treatment notes to patients, particularly where it may be considered adverse to a patient's treatment. Do not release alcohol or drug counseling records of any kind to anyone without first checking with a supervisor. In all of these cases, staff should make sure before they disclose medical information to another person that they are authorized to do so. If you're not sure, please contact your supervisor. Keeping patient information confidential has always been the law. Currently, this obligation is spelled out in the Ohio Revised Code 23-1702 shown on the screen. Please take a moment to read the code. You'll note that this privilege is invoked by the patient and not by the physician. Thus, no information may be disclosed without the patient's consent. Even a subpoena without a patient's authorization will generally not be sufficient to release medical information to a requesting party. There are some limited exceptions to this, so check with legal counsel. The statute highlighted in red makes it clear that this privilege does not apply in instances of child abuse and neglect. And again, if you are not sure, please contact your supervisor. As we learned earlier, Ohio Revised Code Section 149.43 defines what is meant by public records and requires that we, as a public entity, keep and maintain records of our activities available for the public to access. Generally, when we're asked to produce our records under this law, we have to produce them within a reasonable period. However, health records are excluded from the definition of public records. In our clinics, the records we keep are medical records, and they would be exempt from our requirement to produce public records on request. Generally, medical records can only be released when the client authorizes them to be released, or we're otherwise permitted by law to share the records. We'll talk more about that shortly. Importantly, some records that we produce are a combination of public records and medical information. For example, environmental health records regarding lead testing have some information about an individual's medical condition, such as the lead content in a child's blood. Other records have information about being injured from an animal bite. Records such as these need to be redacted to remove the health information and anything identifying the individual whose health information is on the record. Then the redacted record can be produced under a public records request. Where we get an authorization from the patient, however, no redaction is necessary. If you're not sure how to respond to a public records request, check with your supervisor. So how is it determined whether a record is public or not? The general question a court will ask in whether a record is public is whether the requested record documents the activities of Summit County Public Health, or it furthers the public's knowledge of the internal workings of Summit County Public Health. Courts have held that an employee's home address, medical records, fingerprints, and criminal background information from BCI are not public records. Additionally, federal and state laws limit the sharing of certain sensitive information, such as Children's Services investigation records, Social Security numbers, and other information which could be used to commit identity theft. You should be familiar with Policy 522, Data Breach Notification and Identity Theft Protection. If you're asked to share sensitive information, please check with your supervisor first. Now, let's talk more about HIPAA stands for the Health Insurance Portability and Accountability Act, and it's the landmark federal legislation originally passed in 1996, which created strict privacy standards for a patient's medical information. It's important to remember that HIPAA created a number of patient rights, but it also makes it easy to share a patient's medical information for treatment, billing, and operational reasons. HIPAA is a very complex piece of legislation, and it can be confusing at first, but it's very important to comply with it. It gives the federal government very strong enforcement powers and the power to fine healthcare providers who let their health records fall into the wrong hands, or where they can't guarantee that the health records didn't fall into the wrong hands. All breaches of a patient's protected health information, or PHI, are taken very seriously. In fact, the Department of Health and Human Services, which investigates and enforces the law, can fine millions of dollars or even refer certain breaches for criminal prosecution. What's more, failure to comply with HIPAA rules at Summit County Public Health will result in disciplinary action and could result in an Ohio lawsuit or even criminal prosecution. HIPAA requires us to discipline employees who breach HIPAA rules protecting our patients' protected health information. Next up is a video on HIPAA created by the Nebraska State Medical Center.
I was really surprised about his test results. I really didn't think they'd indicate that he had hepatitis.
I know. I was surprised, too. We're going to have to take extra precautions when he comes in now.
What patient are you guys talking about?
We're talking about Mr. Jones. He's been in our clinic every week for the last 3 or 4 weeks.
What you see here is a severe breach of patient confidentiality. When staff members discuss personal patient information where other people can overhear, patients lose trust in our healthcare system, and the system can be liable.
We have a binding pact with our patients to maintain the confidentiality of their health information. This is vital to our commitment of delivering the highest quality of patient care. The new federal law called HIPAA reinforces that responsibility. Our healthcare environment is changing daily. New information technology provides us with an amazing list of new methods to diagnose illnesses earlier, identify potential medication errors before they occur, and communicate instantaneously with other healthcare providers from around the world. However, with those new technologies comes an increasingly difficult challenge to keep our patients' health information private and secure. Please pay close attention to this video. It will provide guidelines on how we should protect patient information in our daily work. We provide our patients, our community, and the region we serve with extraordinary care. Let's all make a pledge to live up to our promise and keep our patients' health information confidential.
While patient confidentiality has always been important in healthcare, HIPAA now provides patients with federal privacy protection. First off, do you know what HIPAA stands for? Not hardly. It means Health Insurance Portability and Accountability Act. HIPAA consists of three major parts: billing, which requires standardized formatting; privacy, which protects patients' health information and how we use it; and security, which outlines safeguards you must follow with your computer and campus networks. This video will focus on how the privacy and security regulations affect you. Key to the privacy regulation is knowing how protected health information, or PHI, may be used. Protected health information is individually identifiable health information, such as a patient's medical record.
We use protected health information daily for patient care, billing, research, and teaching. We need it to perform our daily work, but we must always safeguard this information to keep the patient's trust.
If patients do not believe their personal health information will remain confidential, they may be reluctant to access our healthcare facilities. Worse, they may be hesitant to share important details with us that are vital to diagnosis and appropriate care.
So, do you have any other questions for me today?
No.
Okay, well, it's great seeing you. I'm just going to have you go out to the front desk and make an appointment, and we'll see you at your next appointment.
Okay, thanks.
Great, bye.
I thought you were going to tell her that you were depressed. Why didn't you?
Well, I was going to, but I saw Elena at the front desk. You know, she lives in my neighborhood, and I was just worried that she was going to go tell everyone about my problems.
Here are ways we can safeguard PHI and maintain patient trust.
This psychiatry rotation has been very interesting. Do you remember our new patient, Tammy?
Yeah, I do.
Well, she's the branch manager of my bank. She has always appeared to be a stable individual. I was shocked to find out that she has bipolar disorder and auditory hallucinations. She honestly thinks God is telling her to be the CEO of the bank. Can you explain this to me?
Well, I think those are interesting observations, but why don't we talk about it upstairs? There are other people here that aren't team members.
Okay.
Do not discuss confidential patient information with others who are not involved in that patient's care. Pull curtains, lower your voice, or close the door in patients' rooms.
Hi, Marilyn. How are you today?
Oh, hi, Holly. I'm doing good. How about you?
I'm doing good. Hey, guess who I just saw on the oncology floor?
Who?
The mayor.
You're kidding.
I wonder what he's doing here.
I don't know. Let's go in and look.
Okay.
Do not access patient information unless you have a need to know to perform your assigned duties. Also, you may not look up information on friends, relatives, or others, even if you have their permission. Accessing confidential information without a need to know can result in corrective action up to and including termination.
Hi, you look busy.
Hi, Dr. Lewis. What brings you here today?
I need to review some records on women between the ages of 30 and 50 with diabetes.
Okay, and what do you intend to do with this information?
I'm thinking about doing a research project on it.
Okay, so what I'll need you to do is fill out our standard research preparation form, if you'll just come with me.
Sure.
HIPAA also applies to research. Generally, a researcher must obtain the patient's authorization to use his or her PHI for research. However, A patient's PHI may be used solely to prepare research proposals if the researcher signs a research preparation form.
Got a medium hamburger mushroom pizza, 1106, 20. $9.94 is your change. Thank you.
Be sure to verify all fax numbers before sending confidential patient information.
Hi, we have an appointment with Dr. Walburn.
Hi, and what's her name?
Claire Smith.
Do you have your insurance information?
Yeah.
Okay. There you go. It might be just a couple minutes. Would she like some crayons and paper to draw with?
Sure. Do you want to cover?
Yeah. There you go.
Thank you.
Thank you. Okay, let's go.
Confidential information that is no longer needed should be shredded or properly disposed immediately in a recycling bin. Here are other tips on how you can keep patient information confidential. Place patient charts face down in clinic room doors so passersby can't read the name. Face computer screens away from where the public can see them and log off when leaving your computer. You can compromise the integrity of the network where patient information is stored by inadvertently introducing a computer virus. Only open email attachments that have been run through an antivirus program. Keep your password confidential. Do not use a password that can be easily guessed. Do not write your password down where others can find it, and do not share your password. Open email attachments only from trusted sources. Report suspicious activity to campus security and any out-of-the-ordinary computer activity to the Information Technology Help Desk. ITS will then review the current technical safeguards to determine if changes need to be made. HIPAA also provides patients with several rights. They will receive a Notice of Privacy Practices that describes how we may use and disclose their protected health information and their rights. These rights include the right to review their record and request to amend the information it contains, request restrictions on how their health information is used, request private communications. For example, requests to be contacted at a certain phone number or a special mailing address. File a complaint with the Patient Relations Department or with the Secretary of Health and Human Services. An accounting of disclosures beyond treatment, payment, and healthcare operations. While these disclosures are required or permitted by law, we must now keep a record of them. Examples include, but are not limited to, reports to the Food and Drug Administration, infectious disease reporting to the state, and record review for research. It is your responsibility to be familiar with these HIPAA policies and procedures. Remember, the government can impose penalties, including fines and imprisonment under HIPAA. If you have any questions, speak with your supervisor, contact the HIPAA Privacy or Information Security Officer, or visit our website. Additional information is available from the HIPAA selection on the Internet pages.
HIPAA is far-reaching and affects many areas of our daily work, whether it be in patient care, research, education, or outreach. We all must become familiar with the many policies and procedures that govern the protection of patient information. The best advice I can give you is to live by the golden rule of confidentiality. Treat a patient's information the way you would want your own information treated. I believe protecting patient information is everyone's responsibility, and it's part of our culture of excellence here.
purpose of HIPAA has actually changed over time. At first, it was intended to standardize privacy expectations for patients, but it has grown significantly to govern the standards to be used for protecting electronic medical records and how such records should be shared, stored, and protected. Although the original aim was to make things simpler and cheaper, the most recent changes to the law in 2013 have made HIPAA a penalty-based compliance system. Generally, any time protected health information is lost or accessible by unauthorized persons, the law may presume that a breach has occurred. The 2013 regulations impose very high standards for us to maintain. There's a lot to HIPAA, so let's start with the basics first. HIPAA defines what it considers to be PHI very broadly. Anything that links a person's identity with any past, present, or future health condition will be considered PHI, and it must be protected by us. If a person can look at a document and figure out whose medical information is on it, say by an address, medical record number, or anything else describing who that person is, who their relatives are, or where they live, it is PHI. Under HIPAA, Summit County Public Health is considered to be a healthcare provider. The definition of what a healthcare provider is can be seen on this slide. Essentially, we create and transmit PHI in our normal course of business. This means that we have special obligations to protect the PHI that we hold. Because of these special obligations, Summit County Public Health is considered to be a covered entity under HIPAA. The following slides will look at some rules of thumb regarding HIPAA compliance. Rule of thumb number 1. Summit County Public Health may not use or disclose protected health information unless there is proper authorization to do so. Do not disclose any PHI unless you're sure that the release has been properly authorized. Patients have the right to request a copy of their records, but they must sign an authorization for them. Signing an authorization is necessary unless it falls under an exception, which will be covered in Rule of Thumb number 2. If a person claims to be the guardian or have power of attorney, verify their identity and check the chart for any notes. For example, we want to make sure we don't release information when we've been informed that a power of attorney was revoked. That would be considered a HIPAA breach and would, more importantly, violate a patient's privacy rights under HIPAA. If you're not sure whether to release medical records to someone, always check with your supervisor first. Rule of thumb number 2. Summit County Public Health can share PHI without an authorization when it's for purposes of treatment, billing, or operational reasons. This rule of thumb sets out the key exceptions to rule of thumb number 1. HIPAA is clear that there are certain times when the patient does not have to consent for us to share PHI. Imagine the billing process for medical treatment if we had to get the patient's consent every time. HIPAA did not intend to create those kinds of obstacles. Instead, it specifically says that we can automatically share information with a patient's doctor or insurance company or even a billing contractor. Other instances where sharing is permitted is for purposes of treatment and operational reasons. We'll look at each of these more closely on the next slides. Treatment for HIPAA purposes is defined fairly broadly. Here, it should be taken to mean the provision, coordination, or management of healthcare and related services, the consultation between providers relating to an individual, or the referral of an individual to another provider for healthcare. Billing activities here are also interpreted fairly broadly. They constitute activities undertaken to obtain or provide reimbursement for healthcare, including eligibility or coverage determinations, billing or collection activities, medical necessity determination, and utilization review. Sometimes a patient can proactively request that information not be shared, but this will be uncommon. If a client does not want their insurance company to know that they were treated here, they can request that we do not send their treatment or billing information to their insurance, but the patient must pay for the services up front. This is explained in our Notice of Privacy Practices, which should be posted in a prominent place in every clinic and should be offered to each of our clinic patients. The third occasion where a patient's permission is not needed is where the information is shared for work-related reasons. These can include quality assurance, assessment or improvement, conducting or arranging medical review, legal or auditing services, and general business and administrative activities. So if we're training students or discussing a medical problem for work-related reasons, it's okay to share. But it is not okay to share a person's PHI for purposes of gossip. Sharing PHI with a work colleague is not okay unless there's a work-related reason for it. Gossiping about a patient's medical condition or viewing a patient's medical records without proper authorization will not be tolerated. Rule of thumb number 3. Some public health activities can be shared. We're different from many covered entities because we, as a public health entity, must share information with the state of Ohio and the federal government. HIPAA allows us to share information as we're required to do under state law, but we must still take care to treat the information as confidential. Take a moment to read this slide, and in it you can see that the HIPAA regulations authorize us to share information under our public health functions, but only where authorized by law. As always, if you're not sure whether sharing of certain information is authorized by state law, ask your supervisor. This slide shows a few situations where HIPAA authorizes us to share PHI without the authorization of the subject of the PHI. We cannot pick and choose when to share PHI under the law. It must be required by law, and the requirement must tell us with whom the information can be shared. Please note that subpoenas are not on this list because they're generally not sufficient to force us to disclose PHI. If you receive a subpoena or court order and are not sure what to do, please contact your supervisor. Under HIPAA and Ohio law, we are required to take many precautions to safeguard PHI. We must implement administrative safeguards, such as tracking visitors within the building and having procedures in place for storing and accessing PHI. We must take technical precautions to ensure that no unauthorized persons access electronic PHI, such as maintaining strong passwords and limiting access to PHI on our networks. We must also implement physical safeguards, such as locking file cabinets and not letting passers-by stare at our computer screens when PHI is displayed on them. We also have to plan the securing of PHI during emergency situations. We all have an important role to play in keeping the PHI we hold safe. No matter what division you're in, you will likely encounter PHI, and you have an obligation to make sure it does not get into the wrong hands. If you see something that causes you concern, we expect you to say something. It's very important that we correct problems before they result in a breach of PHI. Employees who fail to report a problem regarding the unauthorized access of PHI will be subject to discipline. Subcontractors in this context are agencies or organizations to whom we transmit PHI in order to provide services. HIPAA refers to these subcontractors as business associates. The law requires us to have all business associates sign business associate agreements. For those of you who are involved with community health programs, it's important to recognize that we must hold our subcontractors to the same standards of protecting PHI that we are held to. We can share PHI with our subcontractors if they execute a business associate agreement. Business associate agreements must be executed under HIPAA law when we share PHI with contractors. Rule of thumb number 4. Covered entities must make reasonable efforts to request or provide only the minimum necessary PHI to accomplish the purpose of the use, disclosure, or request. HIPAA requires us to keep our information sharing to a minimum where possible. If we're not asked to supply all of a patient's records, then we don't supply them. Read any request for records carefully and provide only what's asked for. If the request is unclear, contact the requester and find out what they need. This rule applies internally as well. Only share the minimum information necessary to accomplish what's needed to be done when sharing PHI with coworkers and colleagues. Gossiping about someone's PHI is not appropriate and constitutes a breach of HIPAA law and of Summit County public health policies. We must make sure that PHI is accessible by the fewest number of persons possible. Being a nurse, for example, does not permit you to see a medical chart if the person was not your patient. We must have rules and procedures in place which restrict access to PHI unless it's part of your job to access it. As you can see on the screen, we, as a covered entity, must identify the fewest number of people who need to have access to PHI as part of their job duties, to establish procedures to limit access to those people, and to discipline people who improperly access or allow others to access PHI without authorization. Of course, where information needs to be shared for medical reasons or to the patient, more information sharing is warranted and the minimum necessary principle should not be applied. Examples include requests from providers for treatment purposes, uses or disclosures made by or to the individual who's the subject of the PHI, uses or disclosures according to an authorization, disclosures to the Secretary of U.S. Health and Human Services, and uses or disclosures required by law. A breach of HIPAA is an extremely serious matter. On the next few slides, we'll go over what constitutes a breach, what happens when there is a breach, and what to do if you suspect a breach has occurred. The general definition of breach under the 2013 HIPAA regulations is stated on this slide. It's defined as the unauthorized acquisition, access, use, or disclosure of PHI which compromises the security or privacy of the information, except for disclosures to an unauthorized person who would not reasonably have been able to retain such information. This definition is fairly technical, but in essence it means this. Anytime an unauthorized person gets a chance to view and retain PHI, a breach has occurred. Moreover, if someone accessed the PHI without authorization, or could have accessed the PHI without authorization, it must be investigated as a suspected breach by the privacy officer under set procedures established by law. HIPAA requires that any suspected breach be investigated by the privacy officer. The privacy officer must take the following factors into account when determining whether a breach has occurred: the nature and extent of the PHI, the identity of the unauthorized persons, whether PHI was actually acquired or viewed, and the extent to which the risk has been mitigated. If a breach has occurred, the breach must be reported to the Department of Health and Human Services. Under the 2013 HIPAA regulations, we must do all we can to report breaches and to mitigate any harm that could be caused from the unauthorized access of someone's PHI which was in our care. If you make a disclosure by accident, it's important to tell your supervisor right away. If anything can be done to control the information from being spread to other unauthorized persons, we must be proactive and do it. You must also be proactive when you see someone else access PHI without proper authorization. If you see something, you must say something, because we are required to report all breaches to Health and Human Services. Of course, if you're not sure whether a disclosure was authorized or unauthorized, ask your supervisor or contact the privacy officer. In addition to protecting patient privacy, HIPAA also gives patients a number of rights regarding their PHI. These rights include the right to access, accounting, amending PHI, communications, complaints, notice of privacy practices, and notice of breach. This list is not exhaustive. More detail is provided in our notice of privacy practices. All patients have a right to access the notice of privacy practices. It's a valuable document which spells out the patient's rights. The notice of privacy practices must be readily available to all patients and clients. It must be posted in a prominent location, must be provided at the time of service and upon request. It must be posted on the website, and it must explain all rights and obligations. Here are some final thoughts to keep in mind. Be sure to read the HIPAA manual and ask questions. Remember that lack of knowledge of a breach is not a defense. If you're uncertain about whether to share PHI and you can't get an answer right away, don't share it. If you see something, say something. And as always, if you are uncertain about whether to share PHI, ask your supervisor. Remember, we are all responsible for protecting PHI. This concludes the Privacy Law HIPAA training session. Thank you for your time.